Before I start this lecture, I want to bless it properly. Ori, guardians, warriors, ancestors, angels, I command thee to reverse all spells, curses, hexes, and negativity brought towards me. Whoever may be out here aiming to do me harm, go to them now and snap their necks like a charm. Ori, guardians, warriors, ancestors, angels, I command thee. For all those that are out here aiming to do me harm, go to them now and snap their necks like a charm. So it is, so it is, so it is. Ori, guardians, warriors, ancestors, angels, I command thee. For all those that are out here aiming to bring me harm, go to them now, snap their necks like a charm. So it is, so it is, and so it is. All right. Well, I'm also going to pour libations before I begin this lecture to the great mothers, Nanny, Ashe, Harriet Stanley, Aunt Vi, Ashe, Empress Verdiashi, Tierra, Mother of Washita, Ashe, Empress, Khalifa, namesake of California, Ashe, Queen Charlotte, namesake of Charlotte, North Carolina, Ashe, Mama Chinbi, known as Martha the Dominator, Ashe, Queen Sheba, Ashe, Oya, Ashe, Mama Wata, Ashe, Divine Mother Nature, Ashe, all ancient divine mothers of creation, Ashe, all ancient rulers of the earth, Ashe, all divine mothers that brought forth the divine seeds, Ashe, all known and unknown, great mother goddesses, great mother spirits, Ashe, Ashe, Ashe. All right, I'm going to touch on some things, decoding the law, as some things have been asked of me. I'm going to let you know specifically in the law. I want to share with you all that the codes that are being imposed upon us is not law. It's just that United States codes. So first off, there's a lot of us that like to or have to seek refuge and want to file cases within the court system that cannot afford it. First off, I'm going to show you why most of the time these get dismissed, or they get dismissed or sent back based upon a claim that they say you have not made a claim for which relief may be granted. I'm going to show you why. I'm going to show you how to decode what they are saying when they write background and orders and reports based upon your filings or our filings. First of all, as I stated recently, we are immune from their laws, and in so many ways they tell us this. I'm doing this video because a brother informed me that they basically dismissed his case but remanded it back to the state court, and he told me that they had given him my case law and basically letting him know that he had not properly addressed the court. So they dismissed it for a claim for which relief could not be granted. And basically they were telling him that he did not give them anything to rule upon because he is exempt due to his status, he has immunity. See, looking at these court documents and reviews of the court, Supreme Court cases, and so on and so forth, I've been able to decode what they are saying. See, although they are saying, many times this is a word right here they'll give to us. And I'm sure y'all familiar with that. Okay, the word frivolous, to them, when they say it just means that it is referring to the fact that by them not having by you being immune and them not really having jurisdiction, they cannot really tell you that. So they'll go around about in various aspects of the law or of their code, and they will tell you in so many words they don't have jurisdiction. And a lot of us think by these words that it means that it doesn't have value, or what we're saying in our cases don't have value. This word right here, they consider it elastic. This is an elastic word that is not applied liberally. Okay, to them, the word frivolous is just saying that what you're saying lacks an arguable basis, either in law or in fact. Let me say that again. This word right here, to them, when they say it to us, purely means that what they are looking at lacks an arguable basis either in law or in fact. So if you are immune due to their codes, it is frivolous. This is why the Spirit is moving me to understand that it's time for us to start writing our laws and giving orders. Because if we really understand who we are, there is nothing that they can provide us with. They cannot provide us with a remedy. So it's always the case of this. We go in and out of their jurisdiction by giving them jurisdiction. The fact that we go to them for refuge or questioning, that's because we don't have our own venue. Soon we will. We have one in Philadelphia. Okay. We will soon have our own venues to adjudicate our own matters under. The only reason we go to them is because we think we're getting law, but we are not experiencing law within their corporate construct. There's no way we can, even at the federal level. This is at the federal level, a case that I'm looking at. So right now, I'm just breaking down the word frivolous for those of you that just came on. Basically, we get this word a lot. Am I right? We get this word quite often with the IRS, with federal matters, matters of the state, so on and so forth. This word right here. If you look up, and you all gonna have to do your own research. I'm just a guide. I know what these definitions and everything mean, but I don't hold hands. So I'm just giving you a seed. I want y'all to see this and be able to go put your hands on it for yourself so it can be in you like it's in me. This word right here, frivolous. Okay, when they give it to you, when they put it on our documents and they tell us, okay, this is considered frivolous. It's considered frivolous because if you have already placed your status on the record and you clearly have stated for the record your status, which dictates jurisdiction. So if they know they don't have jurisdiction, they have to tell you that what you have presented is frivolous, because the word is to them means many things. They consider it capacious, Capacious. Pronounce the word, y'all. This is what they consider it as. Capacious. So anyway, the word means capacious. It is roomy. That means they have room to use it in many different fashions. So let me show you how they're using it in this one. They give, in this particular case right here, this is a L. This is a case in North Carolina. I got several case laws. So we have case law here in North Carolina. Okay. This is case law on the books, and a lot of it is unpublished. But this particular case is on the books. You can go and look it up. The capaciousness, they call it. Okay, they're giving this definition of the word frivolous. Right here. Okay, it says the terms capaciousness directs lower courts to conduct a flexible analysis in light of totality of the circumstances. So basically they're letting us know that this is a term, they're speaking of the term frivolous. Let me go back a little bit. Okay, this case right here had to do with coming to the court on informa pauperis, meaning free filing, right? So they basically said in so many words that, you know, we don't have jurisdiction and you have not given us enough to have jurisdiction. So basically, under Title 28 USC Section 1915, as to frivolous filings, is for a failing to state a claim and or due to the defendant's immunity. So they telling you right there that it's frivolous because you have immunity, Moors, especially if you have already put your case into the record. Okay, this is Title 28 USC 1915 E2. Is frivolous in nature because the defendant who is immune from such relief. The reason why you are immune is because of your status, but they're not going to tell you this and break it down for you like this. Okay? And this is the other one they use. And or, okay, this section right here is a common section for them to dismiss things. That's Title 28 USC Section 1915 E2. Okay? But we don't know how to decode what they are saying when they send us back these opinions. When they send us back these opinions saying it's frivolous, it is frivolous to them because you have not given them the authority to rule against you. You know, when they say the word frivolous, it is referring to the court. The court refers, or judges refers to the word frivolous as what you are saying lacks an arguable basis, either in law or in fact. Okay, so once you tell them on record of your status and who you are, then you come back and say all this other stuff. Then you come back and ask them for relief under their jurisdiction. It is frivolous because you have already let them know you wear the black robe. You are the heir to the land and you are immune. So therefore, anything you say after that, they'll call it frivolous. And sometimes they will lock you up for, they'll put you in an insane asylum. Back in the day, they used to do that all the time because they feel like you're not competent and somebody just told you to say this. They're going to test you at least 3 different times to see if you know what you're talking about. So the word frivolous, they consider it to have many vast meanings. It's spacious. They have room to play with that word. This opinion that I'm decoding right now, they're calling it capacious because it could mean more than one. It has a wide range. Okay. So basically, they're saying, dealing with the word frivolous, they come out and say it in this case right here. They come right out and say it. They say the term frivolous. Let me find it. They're speaking of let's see. Okay, the word frivolous. Okay, I was already at it. I thought that I had stopped on it the first time, but I lost it. Okay. The word frivolous is inherently elastic. That means it's a wide range and not susceptible to categorical definition. That means you cannot take this word literally. They're telling you right there what the word means. Okay? They're letting us know. So if you look at these opinions and these writings from the court long enough, you'll begin to be able to decode what they're saying without them actually saying it. And this is it just comes in time that you'll learn this stuff if you're looking at it quite often. So I'm decoding what they're saying right now. So they're letting you know that because of your status, you are immune, and anything you claim after that is frivolous, because frivolous to them is a word that just is saying that what you have presented to them lacks an arguable basis, One, they cannot argue on a fact. Your status is not an arguable basis. Okay? So either it lacks arguable basis, or in a law or in fact. So therefore, it is really nowhere for them to go after that. So we're at a point where it's really time for us to start adjudicating in our own courts, which we are in the process in at least 25 states putting up our counselor courts. But this is basically what they're saying. And in this case right here, Netsky versus Williams, I have used this in my affidavits plenty of times against them, because and I'm going to read some of my affidavits that are some straight headbangers that have shut down everything, with one page. But you guys got to know what to put in there. It doesn't take 63 pages, 123 pages like some of my documents are when I'm really trying to educate them. Okay, so they said all of that, and they gave us a case law based upon their decision, which is how it's properly done. If you ever get something from the Supreme Court or the federal court that does not contain any background on the discussion or the decision and how they came to the decision with case law, it's not valid. I have gotten a one pager. Okay, this one is like 5 pages or whatever, and giving the defendant and the plaintiff a whole dissertation on why it's being remanded back to the state court. Well, I appealed a case dealing with that housing matter, and it went up to the Supreme Court. The Supreme Court of North Carolina sent me back a 1-page that said dismissed. That in and of itself is invalid. Okay. Anytime they give a decision, they have to tell you why, and they have to break it down with supporting case law. So basically, they said all of that just to say this. In the end, this is dismissed. They said it's trying to see where my camera is. Okay, it's dismissed that this action be dismissed under Title 28 USC 1915 E2 as frivolous for failing to state a claim and due to the immunity of the defendant. That's telling you right there. Are they not? They telling you in a way that they cannot really expose themselves, but they telling you right there, and it's signed by a United States magistrate. Okay, due to the defendants, it says and or, it is recommended that this action be dismissed under Title 28, which is a code, is not a law, 1915 E2 as frivolous. And frivolous is what? Frivolous just means that they're saying that what you have presented lacks an arguable basis either in law or in fact. All right, so frivolous is not what most of us determine or think that it means. So, once again, it's being dismissed based upon the fact that the defendant is immune, right? So we got to learn how to read between the lines and decode this stuff. So it's being dismissed under Title 28 USC 1915 E2 as frivolous for failing to state a claim due to the immunity of the defendant. Let me show you why you are immune. Here's the statute that I use so well in the state of North Carolina. Here's the statute. Motion to dismiss grounds applicable to all criminal pleadings. Dismissal of proceedings upon death of the defendant, or A, the court on a motion of the defendant must dismiss the charges stated in a criminal pleading if it determines that all of these different things, if it determines the statute alleged to have been violated is unconstitutional on its face or as applied to the defendant. See? It shall be dismissed upon motion that the statute alleged to have been violated is unconstitutional on its face or as applied to the defendant. 2, the statute of limitations has run. That one's common, but it's a lot of them in the statute that we're not aware of. So I'm gonna read them to you, and then I'm gonna rest upon the main one, and I'm gonna show you all the affidavits that I use and have used to shut the city and the state down completely, based on just that immunity that they know we have. The defendant has been denied a speedy trial as required by the Constitution of the United States and the Constitution of North Carolina. Another good one. I've used that in the past. 4, the defendant's constitutional rights have been flagrantly violated. Oh yeah, this is the one I used against the DA. The whole DA's office. I used this whole chapter. And the DA, they don't arrest me. They don't take nothing that got my name on it anymore. So that's okay. Number 4, the defendant's constitutional rights have been flagrantly. That's a beautiful word. Use all they stuff against them. I love to do that. This is their law anyway, that our ancestors put in place to keep our subjects in line. Y'all got to really know the history of the law. Okay? That has been converted. It says it, let me revert real quick to this right here. It says it right in here. It says it right in this code right here. At the top, it says this, let me see. Oh, I know where it was. It's in here. Okay, this federal court admitted that this is not law. This is what the federal, they have taken information, the legal background in which they are using, right? The federal informa pauperis statute, first enacted in 1892, and now codified at 28 U.S.C. 1915. Do y'all know what that means? They are telling you they have taken the federal statute and placed you and the statute into a fictional status under a code. This is how they're able to take you out of your proper status and take the other American citizens out of their status as well. But we are attached to the land by birthright. If we had not claimed that, and we were still claiming any type of citizenship under the U.S., they have still found a way to keep people under their codes. And they tell you, they give it right to you, but we don't know how to decode this stuff and read it. It says the legal background, basically, in which they're bringing this legal opinion. Memorandum, opinion, order, and recommendation of the United States Magistrate Judge. They're giving you the legal background. They letting you know that it was once federal statute, federal law, and now, okay, it was first enacted in 1892. The federal law or statute that they're deriving their legal background from came from there, which is now codified. At 28 United States Code, Section 1915. They always let you know up front that they don't have jurisdiction, and they give it to you right in your face, but most of us don't know how to read it. We don't know how to decipher and decode what they're saying. They just told you right there that they took it out of federal law, and it's now found under the codified Title 28. So this is not law. Please know that when you see U.S. codes, it is just that, a code, a policy and procedure, and they use their policy enforcers to enforce their policies and codes. All right, now let me get back. I just remembered where that was. I wanted to touch bases on that. So, where was I? Okay. Now, you can find this code, this statute, wherever you are. So that's the federal code. And here's why you are immune. And this is why they call most of the time our stuff frivolous. And we have not stated a claim. And we have not presented anything to them that they can execute upon. Because once you claim your status on the record, especially at the federal level, they do not play like they play at the state level. They cannot proceed. And we have to learn